Hi, today I'm going to present about the reception of English law in the Malaysian legal system. During the period of colonial rule, the British legal system and jurisprudence was introduced to the states of Malaya. In 1786, the island of Penang was ceded to the British. The first Charter of Justice was introduced in Penang on March 25, 1807, which led to the setting up of a court of judicature which was in the line of English Court of Law and Chancery. The first charter did not contain specific provision for the introduction of English law to Penang, but the successive judicial interpretation of the Fair and Just clause of the charter enabled the courts in Penang to apply English law. Under the Charter of Justice, courts were set up in Singapore and Malacca. The Civil Law Ordinance of 1909 replaced the 1878 Ordinance and the position remained the same. When the Straits Settlements were dissolved in 1948, Malacca and Penang continued to remain subject to English law on commercial matters. Then, starting with Perak by way of the Pangkor Treaty in 1874, the British gained indirect rule over the states of Selangor, Pahang and Negeri Sembilan through the residence system, which culminated in the formation of the Federated Malay States. The states remained under the autonomous rule of their respective rulers or sultans with the advice of the British advisors of the or residents. The Civil Law Enactment 1937 formalized the reception of English laws in the Federated Malay States. Furthermore, for the success of their rule in the Straits Settlements and the Federated Malay States, the British extend in their influence to the other remaining states. The gradual introduction of English law followed, and by virtue of the Courts Enactment 1940, English rules of common law and equity were made applicable to Johor and Kedah and the other unfederated Malay states that applied English law by way of judicial importation. After that, Sabah and Sarawak were British protectorates until 1946. The reception of English law into Sarawak began with the enactment of the Law of Sarawak Ordinance 1928. English law was introduced into Sabah by virtue of the Civil Law Ordinance 1938. Subsequently, the application of Laws Ordinance 1949 was enacted in Sarawak, which provided for the reception of the common law of England and the doctrine of equity together with statute of general application as administered or enforced in England. After that, in Sabah, the application of Laws Ordinance 1951 replaced the Civil Law Ordinance 1938 and was substantially the same as the Sarawak application of Laws Ordinance of 1949. The Civil Law Act 1956 finally consolidated the reception of English law into Sarawak and Sabah. In 1963, the Federation of Malaya was enlarged to include Sabah, Sarawak and Singapore. Towards this end, an exercise to unify and harmonize the existing laws was performed. The Partnership Ordinance 1961 of Sabah was made a federal legislation, that is the Partnership Act 1961, and applicable to all the states of Malaysia. The Contracts Ordinance 1950 was revised and enacted as the Contracts Ordinance 1950 and was extended to apply to Penang, Melaka, Sabah and Sarawak. The Civil Law Act 1956 finally consolidated the application of English law in Malaysia as a whole with special provisions made in respect of Melaka, Penang, Sabah and Sarawak. On the whole, Section 5 of the Civil Law Act 1956 deals with the application of English law in commercial matters. In all questions or issues which arise or which have to be decided in the state of West Malaysia other than Melaka and Penang with respect to the law of partnership, corporation, banks and banking, and other else. After that, in all questions or issues which arise or which have to be decided in the states of Melaka, Penang, Sabah and Sarawak with respect to the law concerning any of the matters referred to in subsection 1, which is the law to be administered should be the same as would be administered in England. In the like case at the corresponding period, in such question or issue had arisen or had to be decided in England. Besides, Section 3 of the Civil Law Act 1956 governs the general reception of English law in Malaysia in areas not covered by Section 5, that is not mercantile matters. Section 3 of the Civil Law Act 1956 directs the courts to apply the common law of England only insofar as the circumstances permit and safe where no provision has been made by statute law. Therefore, it can be argued that a contractual relationship is the cornerstone of all commercial matters and contract law should come within the purview of Section 5 of the Civil Law Act 1956. Section 5 could be considered to be a more restrictive section in that it does not contain the provisos as found in Section 3. Under Section 3, English law should be applied only so far as the circumstances of the state of Malaysia and their respective inhabitants permit and the local circumstances render necessary. That's all for me. Thank you so much.